Hello, everybody, and welcome to another of our medical legal webinar CME series, which we hold monthly, organized by Dr. Shield, DOBBS, and CHUBB. So, today's topic is on worrying trends in medical malpractice cases, presented by Mr. Sridhar Sundaram, who is an advocate and solicitor in Asman, Davidson and Co. He's no stranger to us, as he's also given us a previous talk in the last CME season. There will be CME points awarded. Now, before we go on to the talk proper, I thought I'd like to explain where you can always find our live streams, because I keep getting this question, how to watch our live streams. So I'd like to share that all you need to do is go to our website, which is dobbs.my. Okay, so you just go to dobbs.my in your web browser, your iPad or your iPhone. Our website is mobile friendly. And then after you visit our website, all you have to do is you can see at the menu medical legal, our SGMC, and so on. So if you click on medical legal, you will get this web page. In fact, in this page itself, you can watch the live stream. Okay, this is basically just an embedded YouTube video. So if you're watching in YouTube and you're watching on this page, it's the same thing. All right. Except that if you watch on the page, we handily embed the Slido for Q&A there as well. All right. And on this page, you'll be greeted by our AI chatbot, Amanda. Amanda will tell you a little bit about Dr. Shield. And if you are interested to get the quotation with the special DOBBS promo code applied, you can click on that green button there, and it'll take you to the free online quotation where you can check what your premium would be. It's all up to you to how to configure. Huh? And if you have questions for Dr. Shield, all you got to do is tell Amanda your name, your email, and phone number, and then Amanda will send it forward to Dr. Shield and they will get back to you soonest. Now, the other thing about our webpage here at the bottom, you will see previous talks. Okay, so the previous talks, although the live stream is over, you can still claim points if you click watch on YouTube. All right, you see the watch on YouTube at the bottom left here of the video. And actually, if you go to that YouTube video, you see the pin comment, and in the pin comment, there'll be instructions how you can still claim CPD points, uh, even though the live stream is over. So that's the system we have. So there's no worry that you can still get CPD points no matter, um, even if the live stream is over. Okay, so back to today's presentation. We would rather you can ask questions after the Q&A. The Q&A will happen after will start after the recorded stream is over, and you can please ask questions at Slido. And the Slido code is 4678008, or if you not use a normal QR code scanner, it will take you to the Slido website or the Slido app if you're using Slido on your mobile. But if you're watching in the DOBBS web page, Slido is embedded there, so there's no need to do this. Okay. Um, and please don't forget to like and subscribe our video so that you'll stay informed of our future upcoming live streams. It also helps the YouTube algorithm spread our video, and it will help. Okay, now it will help others be aware of our live streams. Now, the claiming CPD points, the dentist would have a pre-registration form. We've already displayed that in the web page, and I think the Dr. Shield would have blasted out to the dentist. For the doctors, I'll display the attendance link after the talk. Okay. If you have any questions about claiming points and so on, you can feel free to ask me in the comments or give us feedback in the DOBBS forum. If there are any problems with the stream, such as audio, video quality, also please let me know. We are always keen to improve ourselves. Okay, so without further ado, I'm going to start the talk, and it's a pre-recorded talk lasting about 30 minutes. All right, so Mr. Sridhar will come in live after the talk to answer your questions. So this is Mr. Sridhar's presentation.
Good evening, doctors. My name is Sridhar, and I'm here to talk to you this evening on a topic that is entitled Worrying Trends in Medical Malpractice Cases. I think I might want to change that to Latest Trends in Medical Malpractice Cases, because whether it's worrying or not depends really on which side of the fence you're sitting on. The main topic would be the new kid on the block and the flavor of the month, which is non-delegable duties. And then we'll just touch briefly on aggravated damages and adequacy of insurance coverage, because I think that is really something that is very relevant to your practice. Now, so non-delegable duties. There is good news in the development in law for those doctors who are independent contractors, and we'll get to that later. Now, it's going to get a little bit legalistic, which is why I'm going to throw it at you while you're not in a coma yet. Now, the original position was that the liability of hospitals and doctors was separate and independent. Now, I'm speaking, of course, of private hospitals and doctors who are independent contractors. So if a doctor who is an independent contractor misdiagnosed a patient or was otherwise negligent in the management and treatment of that patient, then the hospital would not be liable to the patient for whatever losses or injuries suffered by that patient. It follows then that if it was the hospital that negligently caused the patient's injuries, then it is the hospital that would have to shoulder the blame, and the doctor, of course, would be left out of it. If, on the other hand, we're talking about a situation like, for instance, in a government hospital where the doctor is employed by the hospital, then the hospital would be vicariously liable for the negligent act of the doctor. Now, unfortunately, vicarious liability and non-delegable duties are often conflated, even by lawyers and in cases. So in our context, which is hospitals and doctors, both principles, i.e. non-delegable duty and vicarious liability, would result in liability being imposed on the hospital for the injury caused to the patient by the doctor. But non-delegable duties imposes a personal liability on the hospital for the breach of the hospital's duty to the patient. So it's quite special, really, because what non-delegable duty does is it creates a bridge between the hospital and the patient. It overrides the doctor. It's a personal liability owed by the private hospital to the patient. So it doesn't matter that you have an independent contractor who's a doctor or a radiologist, janitor, nurse. It doesn't matter who is the tortfeasor. This is a personal liability owed by the private hospital to the patient. So obviously, this is a development of the law, because originally the hospital would not be liable. So in contrast, vicarious liability is an imposition of a duty for the doctor's negligence vis-a-vis the patient. And it is based on the relationship of employment between the hospital and the doctor. So for instance, if harm is caused by a system failure where no individual tortfeasor can be identified, or where harm is caused to a plaintiff under a defendant's custody, then what you have is vicarious liability, but without non-delegable duty arising. On the other hand, if an employee negligently hits a pedestrian while driving a vehicle in the course of his occupation or employment, then the converse applies, which is There is vicarious liability here, but no non-delegable duty. To put it very simply, if you are talking about a duty that arises from the relationship between a doctor and the hospital, then it is a vicarious liability. If, on the other hand, you're talking about a duty that arises between a relationship between the hospital and the patient, then that's a non-delegable duty. So the law then evolved, and the courts have held that whether a hospital would also be held liable for a doctor's misfeasance depended on whether the patient chose the doctor or the hospital. It's like, I can draw an analogy to a Pied Piper. So if the patient would have sought treatment from that particular doctor, regardless of which hospital he practiced at, then the hospital would not be held liable for the doctor's negligence. However, if the patient chose a particular hospital to seek treatment, and once he was at that hospital, merely picked or was referred to a particular doctor, then the hospital would be held liable, even if it was the doctor's misfeasance that caused the patient's injury and loss. So hence the Pied Piper. You follow your heart. If you followed the doctor, then the hospital is not liable. If you chose that hospital because you think that hospital is a good hospital to go to, and then you're referred to a doctor, then it is the hospital that is liable. So I'll refer to the federal court case. Now, the federal court is the highest court in the land. Yeah? So the federal court case of Dr. Kok Chung Seng and another versus Su Cheng Lin and another. This is a 2018 case. The brief facts are the plaintiff, having first sought treatment from Dr. Kok at Dr. Kok's private clinic outside the hospital, then underwent a surgical procedure at the hospital to remove a lump from his forearm. As a result of which, the patient experienced numbness, partial loss of sensation and pain in the area that was operated on, and he had to go for corrective surgery at another hospital. He then, of course, sued Dr. Kok and the hospital where the original surgery took place. The High Court found that both the doctor and hospital liable for the Dr. Kok's misfeasance and awarded a sum of $50,000 as general damages. And the High Court's finding of liability was premised on a principle of vicarious liability and also non-delegable duty. There was no appeal by the doctor to the Court of Appeal, but the hospital felt that it should not have been held liable because it had nothing to do with the doctor's negligence. And the hospital appealed to the Court of Appeal. The Court of Appeal held that the hospital was under a non-delegable duty of care and, in a sense, upheld the High Court's decision. The Court of Appeal also, interestingly, commented that hospitals can avoid the imposition of this non-delegable duty by placing visible signs in prominent places stating that the hospital would not be liable for the negligence of its doctors, or ensuring that there was a disclaimer clause relating to the negligence of its doctors as part of the condition in the admissions forms signed by the patients. Now, whether or not that will still work in light of the latest decision that we're going to come to is up for grabs. The hospital refused to accept or was unhappy with the decision of the Court of Appeal and appealed to the federal court, like I said, highest court of the land. The federal court here, interestingly, reversed both the High Court and the Court of Appeal's ruling and held that whether hospitals are generally vicariously liable for a doctor's negligence would depend on the facts. There could be no blanket ruling. It also held that whether hospitals generally owe a non-delegable duty to their patients would also depend on the facts. Again, you cannot have a blanket ruling. And it then went on to say, on the facts of this case, the hospital was not liable for the doctor's negligence because, on the facts of the case, the hospital did not owe a non-delegable duty of care to the plaintiffs because the doctor's arrangements with the hospital was that the hospital merely provides for the plaintiff's admission. In a sense, he was just borrowing the OT and the necessary facilities for the operation. The doctor's services were generally not subject to the hospital's control or interference, including where the operation should be conducted. The the absence of even a vestigial degree of control by the hospital over Dr. Koch's operation negates vicarious liability on its part. The federal court was also heavily influenced by the fact that the patient had sought Dr. Koch out as a doctor in his own clinic outside the hospital, and it was Dr. Koch who had decided that the operation will be conducted at the hospital, hence the Pied Piper syndrome. Now, this has now changed in the latest development, and I'm sure many, if not all of you, are already aware of the latest federal court case of Xiao Qingyi against Columbia Asia. Now, here, at first instance in the High Court, things took a very different turn. The High Court here held that the anesthetist was liable, but exonerated the hospital from any liability, and the Court of Appeal upheld this decision. The federal court, however, took a very different view from the federal court in Dr. Koch's case and held that the hospital owed a non-delegable duty to the plaintiff and was therefore equally liable as the anesthetist. And they made another interesting point. Normally, if a hospital is held liable and had to pay an award out to court, the hospital will seek an indemnity from the independent contractor, i.e. that particular doctor that it felt was negligent. But here, the federal court held that the hospital did not, in law, have the right to seek an indemnity from the anesthetist because, number one, the anesthetist was not party to the appeal, and in any event, the non-delegable duty owed by the hospital to the patient plaintiff was a personal liability, regardless of who the tortfeasor was. So you will recall earlier on I said non-delegable duty, what it creates is a bridge between the hospital and the patient. So because it's a personal duty, therefore, the court said that the hospital cannot seek an indemnity from the doctor. The brief facts of this case was that the patient, having undergone a tonsillectomy, palatal stiffening, and endoscopic sinus surgery at another hospital, then suffered a bleed at home. He was supposed to go back to the hospital where the original procedure had been done, but it was decided that the A&E of the respondent hospital was nearer. The anesthetist at the respondent hospital had to deal with profuse bleeding at the airlock outside the OT. And sadly, despite intubating him after several attempts and the subsequent surgery, the patient suffered hypoxic brain damage. So the plaintiff's claim against the hospital on vicarious, the plaintiff initially made a claim based on vicarious liability as well, but the plaintiff abandoned that claim at the Court of Appeal. So the federal court, in giving its grounds of decision, only focused on non-delegable duties. Vicarious liability was left out of it completely. And the federal court said that the test for non-delegable duty is applicable and plucked it out from an English case, Woodlands. In that case, a school was held liable for serious brain injuries sustained by a student during a swimming class conducted by an independent contractor. And 3 essential characteristics were identified. Number 1, it arises not from the negligent character of the act itself, but from an antecedent relationship between the hospital and the patient. In the school's case, of course, it's the antecedent relationship between the student and the school. The duty is a positive duty to protect a class of persons against a particular class of risks, and not simply to refrain from acting in a way that foreseeably causes injury. And thirdly, that the duty is by virtue of a relationship personal to the patient. Now, in that case, Lord Sumpton in Woodlands had formulated 5 identifying features where a non-delegable duty of care applies. Dr. Ellen, could I have the slide? So there are 5 points. The first one is patient's vulnerability and dependence. So where the patient is especially vulnerable or dependent on the protection of the hospital against risk of injury. The second point would be antecedent relationship between the patient and the hospital, independent of the negligent act or omission itself, which then places the patient in the actual custody, charge, or care of the hospital, and from which it is possible to impute to the hospital the assumption of a positive duty to protect the patient from harm, and not just a duty to refrain from conduct that will foreseeably damage the patient. It is characteristic of such relationships that involved an element of control over the patient. And the third point would be where the patient has no control over how the hospital chooses to perform those obligations, i.e. whether through employees or third parties. The fourth feature would be that the hospital has in effect delegated to a doctor some function which is an integral part of the positive duty which the hospital owed or assumed towards the patient, and the doctor is exercising for the purposes of the function thus delegated to him, the hospital's custody or care of the patient, and the element of control that goes with it. And the final feature is that the doctor has been negligent not in some collateral respect, but in the performance of the very function assumed by the hospital and delegated by the hospital to him. So I know there's a lot to get into there. So basically, yeah, that's the Woodlands features or tests that will give rise to non-delegable duties. Now, the federal court also found that the Private Healthcare Facilities and Services Act 1998 and the regulations thereunder provided a statutory framework that imposed on private hospitals these non-delegable duties. Now, that's a very legalistic area. I'm not really going to get into it unless somebody specifically asks me questions on that point. Basically, the federal court looked at various sections of the Act and regulations and read them in conjunction with what the hospital advertises on its websites, and came to the conclusion that by operation of the statute, independently of any other position in law, which is the non-delegable duty, the vicarious liability, etc. So independently of that, this statutory framework imposes on private hospitals a non-delegable duty. Now, that's about all I'm going to talk on non-delegable duties. The next is the next topic that I want to touch on is adequacy of insurance coverage. I know all of you all obviously have insurance coverage. Now, what you need to bear in mind is aggrieved patients have up to 6 years from the date of the alleged act of negligence, and even longer if it is a child, to file a legal action against that doctor. You then add another year or two for the decision in the High Court, perhaps another year to go if you go on appeal to the Court of Appeal, and yet another year if you're going to go on appeal to the federal court. That's being quite conservative. So you can see that the amount of insurance coverage you currently have may not be enough for an award by a court anywhere between 4 years to 10 years from now, taking into account inflation and just the general trend of the awards that are being given by courts. So now, the problem really lies in this fact, and Justice Wazir Alam, in the case of Nurul Hasna, which concerned an infant patient who suffered brain injury, had this to say: the award of future damages or cost of future care in Malaysia is done on a once and for all assessment basis, unlike in England, where the damages may be assessed periodically following judgment and liability. Thus, in Malaysia, the victim cannot return to court in future to claim more damages because his or her injuries have worsened, or if unexpectedly the victim has more needs and the original award has proved inadequate. So, unfortunately, judges in Malaysia are sort of being made to look into a crystal ball and decide how much they should award for the losses and injuries, cost of future care, what kind of decline the patient may have in years to come, right up until death. So, of course, that's a very difficult task. And I think judges sometimes feel that they have to err on the side of caution. If the patient or the plaintiff dies earlier, then of course it's a sort of windfall, if you like. I mean, it's a horrible way of saying it, but basically the courts have awarded more damages than the patient actually requires because the patient has expired, or the plaintiff has expired. If, on the other hand, the court does not award enough and the patient, plaintiff, lives longer, requires more treatment, then there's going to be a shortfall. And unfortunately, the plaintiff cannot come back to court and ask for more money. So that is the problem that we have in Malaysia. So I don't know if that's the case, but certainly awards are getting higher. Now, in the case that we just talked about, Xiao Jingyi case, the High Court, in allowing the claim against the anaesthetist, awarded damages of approximately 1.9 million, and that excludes interest and costs. That award was then increased to approximately 2 million by the Court of Appeal. And then following the judgment of the Federal Court, the judgment sum is now 4.5 million. Plus, there have been other developments in this case where in the High Court and the Court of Appeal, they had decided that fees and allowance, which the plaintiff could have received as a director of a company, were not earnings. But the Federal Court reversed that. So the Federal Court disagreed and said the claims with regarding to directors' fees and allowances would be taken into consideration. And the multiplicand, which is a formula for computing earnings, was also increased by the Federal Court. Now, if this is then applied in all later cases, as it most likely will be, it's going to push the figure higher. I'm just going to run through a few cases just to give you an idea of the kinds of awards that are being handed out today. In the case of Nur Zulaika binti Zulzaili, the infant Zulaika was delivered in 2003. She suffered severe injuries to her brain, and as a result of negligent treatment, a suit was only filed in 2018. High Court allowed a claim of approximately 8 million, excluding interest and costs. The Court of Appeal then reduced it to 6 million and held the hospital solely liable. In the case of Nareen Anatlaki Vijayan, it was a patient who was involved in a motor vehicle accident, brought to a hospital, and as a result of negligent treatment, suffered severe injuries to his brain. After trial, the High Court awarded damages of approximately 4.8 million, excluding interest. In the case of Farid Rizal, 44-year-old patient, this is in 2015, suffered severe brain injuries. And his claim was allowed by the High Court, which awarded damages of 7 million, and the total award was increased to 7.5 million by the Court of Appeal. In the case of Yusnita binti Johari, in 2013, suffered severe brain injuries, and the High Court allowed her claim in 2021. Now, she suffered injuries in 2013. High Court allowed her claim in 2021 and awarded 4.8 million in damages, excluding interest. Similarly, in the case of Henry Siang, 22-year-old Myanmar refugee who was assaulted, and unfortunately was given 5 times the intended dosage of ketamine and suffered cardiac arrest and later diagnosed to have severe brain injuries. The High Court allowed 730,000, which is then increased by the Court of Appeal in 2020 to 1.7 million, excluding interest. So I'm afraid you're going to have to look at what you have. You have to look and check whether the insurance coverage that you have today is adequate, bearing in mind that the case could be filed 6 years later or even more, and that the awards that will be given then will take into inflation and the cost of care many, many years in future. Right. Okay, I'm now just going to touch very quickly on aggravated damages. As I've said before, aggravated damages is one of those heads of damages that doctors can easily avoid. General damages for pain and suffering, you're not going to, if you're found negligent, you're not going to be able to avoid it. Special damages, which is the cost of care, so on and so forth, again, you're not going to be able to avoid it if you're found negligent. But even if you're found negligent, you can avoid a claim for aggravated damages if you just follow a few simple rules. How you treat the patient after the event. Aggravated damages is basically where the courts feel that the doctors have added insult to injury. For instance, in the case of Irwa Budiana bin Amsa, this was an infant born in 2015 in a government hospital. He was diagnosed with hypoxic ischemic encephalopathy following his birth. He passed away at the age of 5 years and 7 months, and his cause of death was listed as cerebral palsy. Now, he was born in 2015. Suit was filed in 2019 while he was still alive. He passed away in 2021, just a few months before the trial of the case was scheduled to be heard. The High Court in 2022 awarded the sum of 840,000. It's not really important, but what is interesting is $300,000 was awarded as aggravated damages. The reason the High Court made this award was because it took into account the delay in admitting liability, refusal to voluntarily disclose medical reports, and the way in which the defense was pleaded. So what the court said here was, further, the court takes a serious view of the aggravating features, such as the long delay over 2.5 years in admitting liability, refusal to make voluntary disclosure of medical records, causing the cause of action for negligence to be concealed, and the filing of this claim to be delayed by a few years, and the way the defense is being pleaded and the trial conducted. So this award of $300,000 could have been avoided. It is separate and distinct from the negligence. So it is important to always cooperate with the patient. If there is a query about medical records, make sure the medical records are disclosed. Don't delay. And if it's a clear-cut case of negligence, be careful in how you plead your defense. If it's an indefensible case, then if you nevertheless mount a defense and therefore the court sees it as a sham defense, delaying the case, then the court will punish you. And in the case of Pew Pew Ma, a Rohingya refugee was admitted to labor wards, and slow labor was hastened by administering oxytocin. And when the baby boy was born, an episiotomy incision was made to facilitate deliver and sutured post-delivery. Here, the mother suffered injuries, and the High Court then awarded a sum of $2,400 being the cost of treatment, $1,500 traveling expenses, and pain and suffering for 7 months of $250,000. Now, these are all relatively small figures, but then the court then added to it $75,000 for aggravated damages. And the court said this was because there was oppressive, arbitrary, or unconstitutional action by servants of the government, and the sum awarded as compensation inadequate to punish for outrageous conduct, to mark disapproval of such conduct, and to deter repetition of it, intentional wrongdoing, additional element of flagrancy or cynicism or oppression, causing indignity, discomfort, or inconvenience. The conduct that the court was referring to was that one of the doctors apparently lied under oath and said that he could not undertake the delivery and that the lighting in the labor ward was insufficient. And then he was also found to be non-compliant with SOP. The court also held there was a violation of the patient's autonomy when failing to inform the plaintiff of choices of treatment and the manner in which the medical expert gave evidence. There was also, this is from a lawyer's point of view, there was an application for security for costs, and that was seen by the courts as an attempt to stifle litigation. So you can see aggravated damages is scary because it covers a very wide course of conduct. You know, if you were delayed, if you're not cooperative, if you were rude, if you were arrogant, the way in which your lawyer conducts the case, the way in which your expert conducts himself in court, all of these things can be seen as adding insult to injury. In the case of Ahmad Takif Hamza, it was due to negligence, well, apparent negligence. The court here also held that there was aggravated damages that caused him to suffer permanent disability. So here, aggravated damages of $100,000 again for suppression of medical records, completely unnecessary. Filing of a defense and denying liability despite overwhelming evidence of negligence. So the general damages for pain and suffering was only $350,000, but for suppression of the medical records, the damages were $100,000. Then there was a case of Maria Susila. The patient fell out of bed and then had a heart attack. And here, for pain and suffering, $300,000. And then aggravated damages was $200,000. So, and in the case of a very famous case of Dato Stanley Isaac, here the aggravating factors were failure to follow up on blood investigations, prescribing contraindicated drugs, late and false entry in the medical records, failure to observe the disease condition and act on it, inaccurate entries in the medical records suggesting that the disease was well, tampering with the medical records, and what was held to be a cruel and insulting remark by one of the doctors, where he said that had he had to do it all over again, he would have done it exactly the same. Misuse of in-house experts to try and defeat the plaintiff's claims. So all of this was held to be aggravating factors. So yeah, these are all things that you can avoid. So be cooperative with your lawyers, be sensible, be aware that the courts are looking at behavior after the negligent incident. Your bedside behavior, how you approach the patient after that. Were you cooperative? Were you sympathetic? Of course, you know, you already been told not to apologize or admit negligence because that could negatize your insurance policy. But stopping short of admitting fault, you can always be sympathetic. Yep. So I think that's about all I have for this evening. If you all have any questions, please bring it up for us to discuss later. Thank you, Dr. Allen.
Well, thank you, everyone, Mr. Sridhar, for the excellent presentation. And I'd like to invite Mr. Sridhar on to the stage and also invite all of you watching to ask your questions. So let me check the Slido. At the moment, there are no questions there and none on the YouTube channel as well. I think all crystal clear, Sridhar. Maybe I'll start off the thing. So just to summarize, you said the 3 points which made the medical legal malpractice trends worrying were the number one, for the hospital side, the issue of non-delegable duty, and then it has to be distinguished from vicarious uh,
Yes,
duty. Well, vicarious means it's employer-employee relationship, and then non-delegable means the hospital has some duty or responsibility even if the doctor is not an employee, as in many cases they are under contract, right?
yeah,
So, and the 5 points you brought up from the British judgment, to me it seems like almost every instance it's the hospital has some role, it's not like there's no, I can't think of a scenario where it's entirely the doctor's duty or responsibility. The hospital has no role at all, in patient care. What do you think about that? uh,
yeah. Under the new findings, it does appear to be almost like, to me, it almost sounds like a blanket rule, and that in
mm,
every case, the hospital is going to be liable. Um, I don't know whether if the doctors took heed of the earlier case, the Dr. Cock case, and what the
mm,
federal court said there, which is that hospitals could avoid this by making it very clear that the hospitals are not negligent for the acts. Sorry, the hospitals are not liable for the negligent acts of their doctors, whether by way of posters placed in prominent places or very clear clauses in the contract that the patient signs. That might be the only way that hospitals can avoid non-delegable duties. But even that remains to be seen, because the federal court in the Xiao Qing Yi case relied heavily on the statute, Private Healthcare and Facilities Act, to say that there's a statutory duty which you can't really avoid by uh, clever clauses in your contract or prominent banners. So that remains to be seen.
to me, maybe it seems like you go to an establishment and park in the establishment's car park, and then there's always a disclaimer there: you park at your own risk. But does that mean it's a blanket escape clause for the establishment? You know what I mean? If something does really happen due to negligence of the establishment and your car is damaged,
Yeah,
uh,
that's the famous
that's
case.
something.
That's the famous English case of Thornton and Shoe Lane parking, which we all studied as law students. It all depends on when that exclusion clause was brought to your attention. If that
Mm,
exclusion clause was brought to your attention before you entered the parking area and you had an opportunity to turn your car around and go away, then
mm,
yes, it is applicable. But if that exclusion clause only pops up, when it's printed on the reverse of your parking ticket, when you're already in a
mm.
position where you have no choice but to go into the parking area, then it doesn't apply. But that's different.
Okay. All right. Then the other second thing you covered was how much insurance doctors need to have in their coverage in view of potential escalating awards. And I think to us, the doctors, that's the even more worrying thing, because it's going to make uh, practice very difficult. Because number one, I mean, some doctors are not shying away from more high risk procedures. For example, in ONG, they may not want to do obstetrics and then just practice gynecology, simply because of this and the fact that they may be liable years down the line, even after they retire, because
Absolutely.
because of the child, can still grow and they're covered for, I can't remember how many years. Uh, until they're 18 or something, I think.
That's right. If the parents don't sue
Mm,
on behalf of the child, and the
mm,
child is considered incompetent in law to be able to sue
mm,
in its
mm,
own name, then as soon as the
mm,
child is of age, then the child
mm,
is vested with the rights to sue the doctor. Yeah.
mm. So, I think the issue is it's going to drive up medical costs. That and the first one,
Yeah.
where hospitals will have to also increase their own insurance
Yep.
if they are liable for non. I think there has to be something done. Maybe there has to be a cap or something in terms of the awards, because we think if this goes up and up and up, there's no end to it, and you end up not be able to find any doctor willing to do any high risk cases, and
Yep.
you end up medical fees will become very unaffordable, because it's going to really reflect on, ultimately, the consumer pays in the end of the day, because
Yeah. That is my fear
things
too.
we
Yeah.
get very, yeah. Hmm. I don't know what the situation. Are we going down that rabbit hole where costs escalate because of increasing awards and so on? That's our biggest concern. I think
Hmm.
I'm not sure what the courts and the authorities will need to come to some decision on this. I think some cap needs to be considered. What do you think? If
I don't know how we can do that. I've just been informed. I just got a message just now that a
mm,
woman whose arm was crushed by a lorry, she's been awarded
mm,
7.1 million in damages. This is what we call a runner case, but because
mm,
of the availability of bionic arms,
mm,
the awards have gone up. At one time, you'd get a normal prosthetic arm, which wouldn't be that expensive. But now, with the advent of bionic arms, the same thing is happening in accident matters. 7.1 million. That's
mm,
very sizable claim. And the other thing that people should not lose sight of is aggravated damages, because uh, one is the fact that a lot of insurance policies don't cover it. So that's like a hidden time bomb. Sometimes I think doctors think, okay, as long as I've got adequate coverage, I'm fine. But what sort of damages does your policy cover? The standard policy will, of course, cover special damages and general damages, not an issue. So as long as your cap is high enough, the ceiling is high enough, you're covered. But it may well not cover aggravated damages. As I pointed out just now, the aggravated damages can eclipse the general damages. So you need to look at the fine print in your insurance policy and make sure you're covered for that, or be ready to fork out.
okay. There are some questions coming in Slido, and Dr. Gerard, start off with the earliest questions. In lieu of potential medical legal case following a call to insurance company, how quick does the legal expert swing into action, as time is of essence?
Well, that would depend on your particular insurance cover. I would hazard a guess. I mean, I can't say for sure, but I would hazard a guess that uh, different insurance companies will have different ways of responding um, to a distress call by the doctor. Um, Sadly, I know that sometimes a doctor will reach out to a broker, and that may not always work out very well. Brokers may not always know when uh, the doctor is covered and when that claim or distress call ought to be conveyed to the insurance company. I've personally had experiences where um, brokers have misinformed doctors, and doctors were unaware that they should have had legal representation at an early stage, and they were denied it. So, um, if you're not, if as a doctor, you reach out to your insurance company through a broker, and it looks like you're not getting any cover, do ring up the insurance company directly, send emails, have a paper trail, so that if there's any delay, it's not your fault.
Yeah. So notify your insurance company and lawyers as soon as
Well, you'll have to
that would
notify
be
the
the
insurance
main.
company.
Yeah.
The insurance company
Yeah.
will notify their lawyers. Yeah,
Yeah.
but
Yeah.
first point of
Uh,
contact is either the broker or the insurance company.
Okay. Second question, I think we touched on it earlier, is
Yeah,
car park
yeah,
operators stating park at your own risk. Can I
yeah,
bring it up again? Let's say there's a sign there, park at your own risk. I go and park in the basement car park of the hotel or something,
yeah.
and everything
But
looks fine. There's nothing. Then suddenly, metal piping, due to poor maintenance, rusted, and then it drops in my car and damages my car.
yeah,
Can't
you must
the
realize.
establishment still be found liable because it's due to negligence, poor maintenance?
Yeah, the courts take a very different view where you have personal injury and property damage, two different things. Right.
And it hurt my arm and broke my arm when the thing fell down. I
Ah,
mean, yeah.
yes, then it's a different ball game altogether, right? Because
Mm,
personal injury is viewed differently from property damage. That's just the case.
okay. All right.
And also, as
But
I said before, you've got statutory provisions coming into play here. A car park doesn't
the
employ professionals. You don't have a doctor with a doctor's duty of care, so on and so forth. So it's a very different dynamics. You know.
okay. Uh, I mean the point is at your own risk clause is not a get out of jail free card.
No, no, no,
Mm,
no, no. There's even case law that says just saying at your own risk is not enough. You must go further and say that I absolve liability to myself for any negligent act by myself. You have to really spell it out. And of course, if you spell it out like that, chances are quite a few people might not even bother to park at your parking lot.
mm. Yeah. Yeah. Same with consent forms. I think if you put too many
Yes,
things
exactly right.
there, then nobody will. If you put everything you tell them, and they end up, look, I don't want to do it because you state. It comes to the point that we have to say everything, and even
Mhm.
if it's a 1 in 500,000 chance you will lose an eye, you have to say it.
No,
And
no, no.
then
You
to the
you don't.
layman,
No, Dr. Allen, you don't
huh?
have to. If it's a very small risk of a very small injury, you don't have to. If it's a small risk of a big injury, yes, or a big risk of a small injury, yes. But it doesn't cover everything. I mean that costs are reasonable.
No, but a loss of an eye is a material risk to everybody, isn't it?
Yes, then you have to say it. And I suppose the other side of the coin is this: if every doctor you went to said the same thing to you, right, then you'd be fully
Mm,
aware of the risk you're taking and really be able to decide should you have this operation or not, which is what the law is trying to impose.
mm, mm. Okay. Anyway, we digress. We better go on to the next
Yes.
question in case we're coming back. Why is the anesthetist held in the bleeding tonsil case when the patient did the op elsewhere?
Well, that's a good question. I wish I had a good answer. We don't know because that was never a consideration before the court. No one sued uh, the physician who had done the earlier procedure, so it never came up. So it's difficult for me to answer the question. From what I understand in speaking to doctors is that uh, bleeds following a tonsillectomy are not unusual. Uh, and I don't know what the consent form there said. Was the patient aware that this was a risk? And it's called a break in the chain of causation. Even if there was negligence, and I'm obviously not saying that there was by the previous physician, and that resulted in this bleed, it doesn't absolve the physician who is handling the current emergency from negligence. So you can't say, yeah, I was negligent in the way I dealt with the emergency, but so was the guy before me, because you are the break in the chain of causation. You could have at that point stepped in and saved the patient. So
Yeah.
full answer one is we'll never
Uh,
know because first physician was not sued. And secondly, it is no answer for the second physician to say, well, it's the previous guy's fault.
Yeah. I think the worrying thing, the worrying trend is again dealing with very complex and high risk cases again here, like
Agree.
if you have your anesthetist, you end up being thrown a patient like this in the, you know, induction room or emergency room, and the patient has blood gushing out everywhere, and there will be difficulty in intubation. Of course, there are many techniques of. I'm not an anesthetist, but I understand there are many techniques of intubation and so on. But some cases may be more difficult than others, particularly in a case where perhaps there was previous surgery in the throat for sleep apnea or something, and the whole airway is all narrow, or perhaps his anatomy makes it very difficult. So I think people sitting in the academic castles can criticize and comment you should have done this and that. But actually, you put even the most experienced anesthetists put them in that position. I wonder how many actually can actually save the patient.
Yeah,
And
I do
this
not
is this
envy
is
that
the thing.
anesthetist.
Hmm.
I do
Yeah,
not envy that
and I
anesthetist. And this is where getting an expert, uh, that can actually put forward all of those things which you just said, in a manner that is persuasive to the judge is very important.
yeah. But anyway, I don't have the facts of the case. I'm not a lawyer. I'm just saying from the doctor's perspective, it is very worrying when you deal with very, very difficult cases. And as you said, sometimes, okay, you try your best and you do save the patient, but unfortunately, there's some injury.
Yes,
In this case, brain injury. And you said, I mean, the more darker side is, oh, if the patient had died, actually is better off. I mean, it's ridiculous, but that is not the way we practice. We do our best to save the patient,
of course.
but in the process we can't help it, but there is some injury in the end of the day. You could say that the doctors did save the patient from dying.
Yeah, yeah,
You know,
yeah.
it's just like a cardiac arrest. You do your best. You got patients come in, you do a cardiac arrest, you do resuscitate, and then, but you end up brain dead because of hypoxic brain damage. But you can say, oh, you didn't do, this properly or whatever. You can criticize all the techniques. And at the end of the day, I mean, the doctors are only human. They're doing the best they can to try to save the patient. In fact, they did save the life, but it ended up with some unfortunate adverse effect of brain injury. So this is the thing, that the biggest challenge and worry for doctors when you're in the emergency room or you're dealing with a very sick patient in ICU, and you're trying to operate on a very sick patient, and the outcome is not what we want. And do we expect the doctors to be superhuman, to be 100% fix everything? Some things are really unfixable or very, very difficult to fix. Hmm?
Yeah,
I
I
think, I
agree
hope.
with you. I
Mm,
agree with you. And I'm,
mm,
I'm not saying here in this particular case that the
mm,
experts didn't do a good job. But end of the day, you must understand that the lawyers are not medically qualified. The judge is not medically qualified. And the judge is swayed on by the opinion of these experts. And that is perhaps something that the medical fraternity can do to help this very situation you're talking about. As lawyers, it's not the easiest thing to get an expert. We need more experienced, competent doctors to step up and be available as witnesses, expert witnesses, and be able to convey what you are conveying to the judge. That is one way of turning back the tide, if you like. But you must understand, the judges' hands are tied. They have to listen to the experts. They're not medically qualified. So their judgments, to some extent, depend on how persuasive, how cogent, how professional the experts are. That's one way the medical fraternity can help itself, I think.
So the question at the bottom is the same thing. Your accident victim comes to the emergency department and is unable to be saved.
Mm.
Uh, would that mean the ED doctors can be held liable too?
Yes, but of course, again, it boils down to what the experts say. If the experts say, this guy was, one expert might say he was bleeding so badly, we couldn't take him into the OT to stop the bleed because we wanted to stabilize him. And that's the general rule. Another expert will say, look, there's no point in waiting for him to be stable while he's bleeding like this, because he will never be stable. And if you have to perform CPR whilst he's on the gurney being pushed into the OT, then that's the way to do it. You got to get in there and stop the bleed before he bleeds out. So you have two different experts giving two different views, and the judge he doesn't know. Should they have waited for him to stabilize before taking him to the OT to stop the bleeding, or should they have wheeled it into the OT while he's crashing, performing CPR at the same time in order to stop the bleed? Those are questions that we rely on medical experts to illuminate for us.
Yeah. So in summary, it's depending on the facts of the case.
Yes. So
Yeah.
where a judge has got two differing opinions from two different experts and cannot decide which one is right, then the doctor gets off the hook, right? So the judge must be able to say, I don't agree with one of the expert's opinions, and why I don't agree with that expert's opinion. The usual judicial phrase is that expert's opinion did not withstand logical analysis. And this will come out in cross-examination, where an expert is challenged on the views he has expressed in his report and his testimony, and he's found to be unable to back it up. His grounds or his opinions start to fall apart. Then the judge will say, okay, you gave this opinion, but it doesn't withstand logic and analysis. Therefore, I will go with the other opinion.
Okay. We have hit the 1 hour mark. Maybe we'll just take the last
Okay.
question there, which is
Sorry.
why are judges now awarding such high sums? Maybe not fair for Mr. Sridhar to answer that.
They're not awarding, they're not giving away money because it doesn't belong to them. They are persuaded by the facts of the case as to what is the cost of future treatment. Again, this is where the experts come in and say he's going to need this surgery, that surgery, and the other, and this is how much it's going to cost. Physiotherapy, he's unable to move, therefore he will have to renovate his house because he can't climb upstairs. He will need nursing care. He will need a specially designed vehicle to move him around. So these are the reasons why judges are giving these awards. And of course, the cost of living is going up. Everything is going up. So it's not surprising really why the sums are getting higher.
So basically, it's not a figure the lawyer can pluck out of the air. Let's say the patient
not.
has
You have
lost.
to justify it.
Okay.
You have to justify it.
If I remember reading in the press, don't know whether it's true or not, to say you lose 2 legs after the operation and then you ask for 50 million. And then, you may have to justify why you're asking for 50 million.
Yeah, it makes a lot of difference whether you're a person who gains his livelihood as a ballet dancer, for instance. Then you lose both legs, that's it, your livelihood is gone. As opposed to someone who sits at a desk and works, then, even though he's lost his legs, he doesn't lose his job. So these are all things that the court will take into consideration.
Yeah. The court should perhaps take in consideration as the sums are escalating. Doctors' fees remain capped for the last so many years.
Yeah. That's where insurance
everything is going up. Yeah,
Well,
malpractice insurance is going up. The wards are going up. Doctors' fees remain capped. Eventually,
it's not a laughing matter.
Yeah,
it's not a laughing matter.
No,
I foresee that at some point doctors might just say, this is too much of a risk. I may have the experience and the skill and the competency to try and save your life, but you know what? I'm not going to bother doing it because I'm worried about getting sued. I'd rather just do the bread and butter cases, and then I can go and play golf at 4:30. I do worry about that. Yes.
Yeah, and then this is not legal, but it's just, I think I read in the news, the health minister has said that we are looking at, the end, not medical legal compensation, but it's not a fee for service, but depending on the success of the case, that means whether you can it's a successful procedure, successful operation, then only there is a fee awarded. Like that, nobody is going to do any difficult case, right? Because
Wow,
the
that's
failure rate is going to be higher the more complicated it is. So,
yeah,
I mean,
yeah.
uh,
I hope that's not
same,
true.
same. No, yeah, I don't know. You end up, everything's going to be shunted to the government hospitals because nobody's going to touch any high risk case. Yeah.
Yeah,
Mm,
that's bad for public policy.
but yeah, but outcome based payment. Yeah, yeah. So Mark, thank you. In the that's what I read in the news, that they are thinking of
Mm,
outcome based payment. I think in the end of the day, outcome will depend on how easy or difficult the case is. Mm,
absolutely,
yeah.
absolutely.
Yeah, but anyway, that's another topic altogether. So I think we've come to the end of the hour.
Hmm.
Thank you everyone for watching, and we have reached the final bit. And I think this is the part where all the doctors are interested to get the CPD points. Um, for the dentists, they've already got the pre-registration link, so not to worry. The Private Dental Association will upload your points for you. If you've got any problems, you please contact your Private Dental Association. For the medical doctors, we'll submit your attendance to the MMA, Malaysian Medical Association. So the second link with the QR code is to this link, dobbs.my slash 310724. This is basically a Google form, so you will mark your attendance, and please submit it before midnight tonight on the 31st of July. So after midnight, the form will become invalid, but you can still claim points by visiting the YouTube video tomorrow, and there will be a pinned comment there to help you claim your point. Um, by following the steps, which is basically you make a declaration in the video that you have watched the video, and then you message us, and we'll help you claim the point for watching. So for those watching live now, please submit your attendance through the bottom form. This is not the MMA QR code scanner, because that one has been disabled for online events. Okay, so this is a normal QR code to take you to that link. Okay, so you can open the link if you're on a computer, dobbs.my slash 310724. If any of you got problems submitting, please let me know. Okay. In the meantime, we will end the live stream shortly, and I'd like to thank Mr. Sridhar again for his time and his excellent insight into pressing and extremely worrying matters, where we are
Not
headed
worrying,
in
not
the
worrying.
country, or not concerning, or maybe things which we are hot in the doctor's lounge discussion and
Yep,
so on
yep.
today. But
Thank you
yeah,
for having me on,
okay,
Dr. Alan.
yeah,
Really.
yeah, always a pleasure, and thank you very much for sharing. So thank you everyone for watching, and we'll see you in the next one on the 5th. This next Saturday, sorry, this coming Saturday, which is the 3rd of August, will be the SJMC Grand Rounds at 2 p.m. Okay, so for the rest of the CPD cycle, for DOBS, the first Saturday, 2 p.m. will usually be the SJMC Grand Rounds, and the Medical Legal Grand Rounds will usually be the last Wednesday of every month. So you'll have two live streams every month. So we only need 20 points. So you stick with us for 10 months, you got your 20 points. Very easy. There's no need to fret. Huh? Okay. All right. Thank you everyone for watching, and good night.
Good night, all.